Welcome to this explainer. Today we are diving deep into an incredibly complex puzzle, the legal architecture of clinical psychology in Nepal. You might think therapy is all about, empathy and active listening, but behind closed doors, every single assessment and diagnosis is bound by a strict, high-stakes legal framework, making just one legal mistake in therapy can literally end a career. So understanding these rules is absolutely essential to professional practice. We're going to teach this in depth today. Now, unlike countries like the UK or Australia, which have this neat standalone mental health act where everything is just in one place, Nepal's system is, it's a bit of a labyrinth. It relies on a really complex, overlapping web of constitutional, health, and privacy laws. And navigating this isn't just some academic exercise, right? It is a daily, high-stakes reality for practitioners who have to make sure they're compliant across multiple fronts, all at once. To teach this in depth, we will build this architecture piece by piece. First, Nepal's mental health legal web. Second, the constitutional foundation. Third, regulating professional clinical practice. Fourth, patient rights and confidentiality. And finally, the missing puzzle piece. So let's start with part one, Nepal's mental health legal web. The absolute crucial point here is that legal competence is just as essential as your therapeutic skill. Honestly, it doesn't matter how empathetic or scientifically grounded your interventions are. If you lack legal knowledge, you can expose your clients, your institution, and yourself to massive harm. Because this network is so decentralized, literally spanning everything from child protection to disability rights, a practitioner kind of has to be a master of multiple domains. A therapist isn't just treating a child. They're legally mandated reporters operating under child protection laws. Moving on to part two, the constitutional foundation. This right here represents a massive legal paradigm shift. The Constitution of Nepal actually recognizes health as a fundamental human right. Think about what that means. It completely redefines the patient from being a passive recipient of charity to a rights-bearing individual. Mental health care is no longer viewed as a privilege, guys. For psychologists, this dictates that all services absolutely must be accessible, non-discriminatory, respectful, and strictly accountable. Because the Constitution guarantees specific protections, like dignity, equality, and privacy, no clinical decision can legally violate them. If you're conducting a psychological assessment, you cannot discriminate or treat a client differently based on their background, period. This constitutional law forms the ultimate foundation that all other health-related legislation operates on. It is, literally, the highest legal authority in the room. Let's look at part three, regulating professional clinical practice. We can perfectly contrast your two main sets of obligations here. Think of it like this. On one side, the 1997 NHPC Act is all about you, the professional. It ensures that only qualified professionals can register, that you practice strictly within your competence, and that you are held legally accountable. On the other side, the modern Public Health Service Act of 2018 is all about the system itself. It emphasizes citizens' rights to quality services, institutional accountability, and, of course, strict record maintenance. And speaking of records, this is exactly why a psychologist's notebook is their most valuable and, let's be real, probably most stressful possession. Under that 2018 Act, these documents, like your case files and treatment notes, are legally binding evidence. In the eyes of the courts and institutions, the golden rule applies. If it wasn't documented, it simply didn't happen. Your paperwork is both your clinical roadmap and your ultimate legal shield. You can actually visually trace this evolution. Nepal has been continuously layering its policies, starting way back with the 1996 National Mental Health Policy to integrate mental health into primary care and reduce stigma, then adding the NHPC Act in '97 to regulate professionals, all the way up to the comprehensive 2018 Public Health Service Act. It's this continuous, steady push toward highly regulated, evidence-based care. Which brings us to part four, patient rights and confidentiality. This act effectively dismantles that outdated charity mindset we talked about earlier. The 2017 Disabilities Act legally mandates inclusive clinical practice. This means if a client has a physical or cognitive disability, your assessment procedures must adapt to be equitable. Disability cannot justify discrimination, for sure. These individuals must be treated as active participants in their care, deeply aligning with modern multicultural clinical psychology. Now, this brings us to an absolute cornerstone of psychology, confidentiality. Clients disclose deep traumas, addictions, messy family conflicts, and really intimate secrets. But as a practitioner, you have to ask yourself a critical question. Is confidentiality absolute? The answer to that is a definitive no. You are legally obligated to balance privacy with public safety. In high-risk scenarios, like imminent suicide or homicide risks, confidentiality breaks down. You have a duty to warn and a duty to protect. Furthermore, child abuse disclosures represent one of the absolute most legally sensitive tightropes in practice. It forces you to balance child welfare, parental authority, and some very strict legal protection obligations. And before therapy even begins, you have to establish informed consent through 4 exact pillars. First, the client must have the cognitive capacity to understand you, meaning they can mentally process the information. Second, their choice must be completely voluntary, with no coercion. Third, you must explain the risks and alternatives so they have adequate information. And fourth, they must actually have the ability to make the decision. Missing even one of these pillars opens you up to severe malpractice allegations. Which naturally brings us to professional negligence. Malpractice litigation is rapidly increasing in Nepal right now. Committing acts like practicing outside your competence or boundary violations, like, say, entering into a financial or romantic relationship with a client, will trigger severe legal consequences. Because clients occupy an inherently vulnerable position, the legal burden of maintaining these boundaries falls entirely, 100%, on the psychologist. Finally, let's dive into part 5, the missing puzzle piece. So, as we've seen, Nepal has built this really impressive, interconnected web of constitutional rights, health legislation, and disability frameworks. But there is a glaring gap in the architecture. Because mental health regulation is scattered across all these different general laws, Nepal lacks one crucial thing: a comprehensive, standalone mental health act. And this fragmented system struggles the absolute most when things get severe. Just look at acute scenarios like involuntary hospitalization, compulsory treatment protocols, or complex capacity assessments. When a patient is in a severe crisis and refusing care, the lack of dedicated, centralized protocols leaves both the patient and the practitioner walking a very, very dangerous legal gray area. Ultimately, while the current web strongly protects basic human rights and professional standards, the system is just begging for specialized legislation. To truly protect vulnerable psychiatric patients and give clinicians clear, safe operational protocols, a centralized mental health act is the necessary next step in Nepal's evolution. But until that standalone act is passed, this is the profound legal tightrope every clinical psychologist in Nepal must continue to walk every single day. So what does this all mean for the future? How will Nepal bridge the gap between protecting constitutional human rights and the incredibly complex need for involuntary treatment protocols? It's a heavy question, and it proves exactly why legal competence is just as vital as therapeutic skill. Thanks for joining me for this explainer, and I hope this deep dive has given you a much clearer map of this fascinating legal architecture.